Welcome to the SC Launch and Learn with Hunter Freeman, partner at the Law Office of Burr, Forman in Greenville. Today we are discussing hot topics in patent law. Before we begin, I'd like to go over two housekeeping items. First of all, if you can hear me, please raise your hand in the webinar controls. All right, Paul, thank you. Anyone else? Let's get a couple people that can hear me before we get started. Great. Thank you, Chelsea, Dennis, Paul, Shane. Thank you. Welcome. I really appreciate y'all being here. You can go ahead and lower your hands. All right. So second item on the table right now is the format of today's webinar. So we will keep all audio muted for all of our audience participants. So if you have any questions, please feel free to type them in the webinar controls at any time. But specifically, we will pause about halfway through for Q&A, and then we'll pause for Q&A again at the very end. So I will be reading the questions out loud, and Hunter will be answering them. My name is Julia Linton, and I serve as the Operations Manager for the SC Launch team with SCRA. And I would like you all to join me in welcoming our speaker, Hunter Freeman, to our webinar today. Through his intellectual property and litigation practice, Hunter serves as a modern-day moat builder. I love that description. And Hunter, I would like to hand the mic over to you to sort of tell us a little bit about that descriptor, and I'll let you dive into your presentation. So welcome, and thank you for joining us.
Well, thank you very much, and thank you to everyone who's logged in today. I know that the lack of in-person interaction can sometimes be considered a disadvantage of a webinar, but I think it's working to our advantage in the days of COVID-19. So I appreciate your time today. So yes, I am an intellectual property attorney. I'm located here in Greenville, South Carolina. And generally speaking, I help clients leverage their inventions, their trade secrets, and their branding to gain and maintain market share by creating barriers to entry against their competitors. On the front end, I can help do that by identifying and protecting the intellectual property of the client. And on the back end, I can help through the enforcement of their intellectual property rights, both inside and outside of a courtroom setting. But today we're here to talk about patents and the hot topics. So we're going to take a look back on 2019, and then we're going to take a look forward to 2020 and see what the pressing issues of the day are. So the topics that we'll cover is we'll do a quick primer on Patent Law 101. Then, of course, given the age of which we're operating in, everyone wants to know a little bit about COVID-19 and how that might be affecting things. Then we'll go into the changes in patent eligibility rules, and that really primarily affects medical diagnostics and software inventions. Then we'll take a look at some pending legislation that is looking at eligibility standards and trying to correct some of the confusion that's going on. Then we'll look at how there's legislation on pharmaceuticals as well as patent enforcement. Then we'll take a look at statutory bars to patentability. Then we'll finish up with inventorship and artificial intelligence, and then we'll just look at some recent trends. So first, let's start off with just a little bit about patents and what they are. So typically there are three types of patents. There's a utility patent, which really the scope of protection is it's for the structural and functional elements of your invention. The term is 20 years from filing. Prior to June 1995, it used to be the longer 17 years from the date the patent was issued or 20 years from the filing date. But now it is typically for patents that are filed anywhere in the recent times, it's just 20 years. But please do check with your patent attorney for things like term extensions, terminal disclaimers, and what rules are going to apply. There are two types of applications that you can file for utility patents. There's provisionals, which are kind of like a placeholder that simply gets something on file with the patent office. They don't even get examined. It's just a placeholder for a year in which that allows you to go out and make public disclosures and use your invention freely without worry of losing your patent rights. And then at the end of the year, if you don't convert it or file a non-provisional application, which is your full-fledged application, then that provisional will become abandoned. But then the non-provisional application will be examined and hopefully will issue into an issued patent. The second type of patent is a design patent, which protects the ornamental features and appearance of an item. It does not protect anything that is functional about the item to be protected, and it does not protect the appearance when that appearance is dictated by function. The term of protection is 15 years from the date of issuance. And design patents can be very useful, especially in aftermarket parts such as the auto parts. I know that there's a restriction against having protection for functional features, but in a recent case, which is the Auto Body Parts Association versus Ford, which is a Federal Circuit case from July of 2019, essentially Ford was able to maintain some patent protection for the shape of its headlight. And it was argued that they should not be able to have that type of protection because it is functional, because anyone who has an aftermarket replacement headlight wants it to match their other headlight. Well, the Federal Circuit said, sorry guys, while it may put you at a significant disadvantage, there's nothing functional about the design of their headlight and the shape of it. So design patents can be a very useful tool in your patent portfolio. The final is plant patents, and the scope of protection there is for new asexually reproduced plants, and those last for 20 years. That's generally when you're talking about genetically modified plants and things of that nature. So let's talk a little bit about patent eligibility and the rights. So the requirement for patentability is governed by 35 U.S.C. sections 101, 102, and 103. And an invention must be useful, it must be novel, and it must be non-obvious. Useful is a pretty easy one. Novel just means no one has done anything exactly like what you have. And non-obvious is typically where you're going to have the fight, which is your improvement significant enough over the prior art to allow you to get a patent? Now, there are certain non-patentable subject matters that have been created, and that is the laws of nature, natural phenomenon, and abstract ideas. And we'll get into those a little bit more later on. But assuming that you are able to get a patent, then you obtain certain exclusionary rights, which is you can exclude anyone else from making, using, selling, offering for sale, or importing any sort of invention that falls within your scope of claims in your patent. So let's go on to a little bit about the policy considerations behind patent law. Patents provide limited monopolies, and as you may know, monopolies are disfavored in this country. In fact, we have the Sherman Antitrust Act to prevent companies from gaining monopoly power. But the government has realized that there's a quid pro quo in that the government gets certain disclosures and in exchange for some protection. So from the government and societal aspect, they get to learn more about your invention. So the applicant must describe the invention so that a person having ordinary skill in the art, or faceta, would be enabled such that he or she could make and use the invention without undue experimentation. So this is the learning process that all of this becomes public, and then people can build off of that to make improvements. Now, the quid pro quo from the inventor side is that they get the exclusive rights that are allowed by patents. So let's move on a little bit to the novelty and non-obviousness. So when the roller skate first came out, it was novel and non-obvious. No one had ever seen a shoe that had wheels on it that allowed you to traverse asphalt or smooth surfaces just by gliding over it. Now, sometime later, you may remember the rollerblade coming out. Again, this was considered novel in that while it was a shoe with four wheels, no one had aligned them quite in this manner. We were used to seeing them 2 by 2 in a square format, and now they were all in line such that they were replicating a blade. And it was determined that this was a non-obvious improvement over the roller skate such that that was patent protected. However, in I believe it was the late 90s, the Air Jordans came out with basically a combination, and it's a little difficult to tell, but if you look right here, there's actually 2 wheels in the back and then 3 wheels in the front. So it's 2 by 2 in the back and then 3 in line. And it was determined that that was just an obvious combination of the roller skate and the roller blade. So that is kind of an example of what you're looking for novelty and non-obviousness. So let's talk a little bit about the first to file and disclosures. Since March 14, 2016, the U.S. has been granting patents on a first to file basis. We used to be a first to invent, but we switched that up to be more in line with the rest of the country because there are just some procedural and logistical headaches about determining who was the first to invent. For U.S. protection, a patent application must be filed within 1 year from its public disclosure. Now, this is not the case for foreign protection. In foreign protection, most of the time, as soon as you publicly disclose, use, sell, or do any of that with your invention, you have lost any ability to get a patent. So you have to file your patent application before you make any of these public disclosures. In the U.S., we give a 1 year grace period, but this grace period is not absolute. So by example, let's say that you come up with a technology that consists of A, B, and the secret sauce C. And you make a public disclosure of A and B, but you hold back for yourself secret sauce C. But then the person to whom you disclose this, they take your A and B, and they come up with their own version of the secret sauce, which is not exact, but it's close, so that's C prime. And they apply for a patent on that. Well, the patent office is actually going to grant them a patent, and that patent may prevent you from getting a patent on your disclosure. So you need to be careful about the 1 year grace period. It's not a free 1 year to do whatever you want. It's the best thing to do is to get your protection in place before you start publicly disclosing your invention to the public. So there's some possible protection timelines that we should discuss. And so we talked about the 2 different types of applications being a provisional application and a non-provisional. So we start off our timeline by doing a best practice of filing that provisional or non-provisional application. And so that prevents you from losing any rights when you make a public disclosure. Because once you make that public disclosure, your foreign filing rights end and your 1 year U.S. clock begins. Now, within the 12 months, if you file a provisional application, you can convert it, file a non-provisional patent application, or if you had a non-provisional to begin with, you can then file a PCT, which is a patent cooperation treaty, basically an international application. And then within 18 months, you can pick the nations into which you want to go into a national phase. So you do have an international application, but there's no such thing as an international patent, issued patent. You actually have to go into the individual countries to be able to get that. But just remember, get your application on file before you make any public disclosures. So let's talk a little bit about what happens once you get a patent. What does that provide you? Because patents can be expensive to obtain. So remember that provides you the exclusive right to make, sell, offer for sale, use, or import. But how do you determine what types of inventions fall within the scope of your claims? Well, I gave you a little bit of a hint. The first thing you have to do is to go to the claims of your patent, which a patent typically has 2 parts. It has a written specification, which is where you describe to the public how to make and use your invention. And then the second part, which is the claims, and that defines the bubble of protection that surrounds your invention. And so if another invention falls within that bubble, it's considered infringement. Now, how do you determine what that bubble looks like? You have to have an every element test. So if I have a claim, I claim a widget with element 1, 2, 3, and 4. If there is another invention out there that has all 4 of those elements, even if it has a 5th element, it falls within my bubble of protection. So even if you make an improvement on my invention, you might still infringe my initial patent, even though you have an additional element that I have not claimed. Now, if a particular element is missing, there is something called the doctrine of equivalence, which basically says If you have something in your invention that performs substantially the same function in substantially the same way to achieve substantially the same result, they're going to say, well, we're going to say that that element is there, and therefore you are infringing the patent. So assuming that you are able to prove infringement of your patent, what do you get? Well, the typical remedies that are available to you are a reasonable royalty, and this is by and large the most common type of monetary reward that you're going to get as a result of a patent infringement suit. And this is just basically determining some sort of percentage of either gross sales or net profits or something of that nature that you will get as the patent owner based on the sales of the alleged infringer. In certain circumstances, however, you can obtain your total lost profit, saying, but for the sale of these infringing devices, I would have made a profit of X, and therefore I'm entitled to my lost profits. And in either of those cases, if you are able to show that you would be irreparably harmed by the continued infringement of your patent, you can obtain a court order that mandates the infringer to stop the infringing activity. Now, if you're on the other side of that patent infringement lawsuit, there are some defenses to you, which is non-infringement, saying, look, I don't meet every element of one of your single claims, so I don't infringe. This may be a similar product, but it doesn't mean that I infringe your patent. Or there's invalidity, saying, well, even if I do infringe your patent is actually invalid because it reads on the prior art, or it shouldn't have, patent should have never been granted in the first place. And then finally, a related defense is unenforceability, which typically arises out of fraudulent activities on the patent office, saying, look, the only way you were able to obtain your patent is through making fraudulent statements of material fact to the patent office, which induced them into issuing a patent that never should have been issued. So why does someone want a patent? Well, patents are assets. They're very valuable. They can be bought and sold like any other piece of property. And then even if you keep them, they can be a different source of revenue in terms of they give you the monopolistic powers. They give you that moat that keeps your competitors out so that you can be the only one in your particular market space who has the right to market and sell this particular invention, which can be very powerful. And then if you decide that you don't want to be the only one in that space, you can then license out the right to others, whether you're making it in tandem with them or you give them the exclusive right. You can make money and allow other people to make and sell your invention. Beyond that, patents are marketing tools. There's real consumer perception, whether right or wrong, that if you see patent number whatever or patent pending, a lot of consumers believe, wow, this must be a better product. The patent office has approved this, and that's not necessarily the correct way of thinking in terms of the utility of a particular invention, but that is consumer perception. And then the final thing is patents can be capital raising tools. So it is an enticing protection for investors. It's a barrier of entry to make sure that once they invest into you, that your competitor can't come along and just duplicate what they have just funded. And then it's also proof of due diligence, because I've seen many a time where these angel investors or other investors talk about, we're betting on the jockey, not the horse. So they want to see inventors or business owners who have skin in the game and who are diligent and are thinking through these things instead of just taking money and running with it. So it shows that you know what you're doing and you're doing your due diligence. So that was kind of a primer on patent law. So let's get into very briefly how COVID-19 is affecting things in the patent world. One item that it can have an effect on is patent ownership. The default rule for ownership is that the inventor owns the patent. Now, there are some exceptions to that. The employer owns the patent if the employee, one, executes an assignment of that invention where it says, I assign to my employer the following invention, or if there's an assignment clause in an employment agreement, which is more typical, which basically says something along the lines, I agree that any inventions that I make while employed here will belong to the employer. But if there's not such a written agreement in place, the employer can still be considered the owner if the employee was hired specifically to invent. Now, there are some factors that you have to look at to figure out whether or not the employee was hired to invent. You have to look, one, to the employment relationship at the time of the invention. One, are they an employee or an independent contractor? That looks at things like the employer's right to control the time and the actions of the employee. Whose equipment is being used, whose facilities are being used, the amount of control. Then the other thing that even if you're an employee, you have to look at the scope of the duties. I mean, obviously a janitor who comes up with a novel cleaning tool is probably not going to be considered someone who was hired specifically to invent a new cleaning tool. Whereas a laboratory assistant or a researcher, they're going to look at that and say, hey, the purpose of your employment was to solve this problem, to come up with this new invention, to come up with improvements. So they look at those types of things. Now, how does COVID-19 affect some of that? Well, nowadays, employees are now telecommuting, working remotely, and working flex hours. So the questions that need to be asked is, how does the employment agreement deal with inventions conceived off-site? So if people are now at home and they're a researcher, you have to look at, whose equipment's being used, whose facilities are being used, how much right of control does the employer have while this employee is working at home. So if your employment agreement doesn't deal with these things, you might need to come up with some sort of addendum or something that deals with issues for prolonged periods of telecommuting or working remotely. Also, you have to look kind of at the scope of the employee's duties and how they've changed. So another instance that you need to think about for working remotely and things is the protection against inadvertent disclosure of your inventions. So we all know when we're at home, it's a more relaxed atmosphere. Your kids are around, your wife is there, you might be willing to share more things with people in your household, or you might not keep your work documents as secure as you do at work. So you have to look at things like, what does your non-disclosure and or employment agreement say about these types of things? You may need to update your policies for remote working. I mean, you need to potentially make sure that your employees are working on secure Wi-Fi network, and that they have the same level of formality and security, where they have a separate office in their house, that they don't leave their documents laying about where family or friends who are visiting could see that. And as an employer, you need to make sure that you're marking all of your documents, whether they're print or electronic, as confidential, to as a reminder to your employees that, hey, these are confidential documents. You need to treat them as such. And then there's another issue about the COVID-19, which is, does the Defense Production Act shield one from liability? So if President Trump declares that these private companies need to start making personal protection equipment, are they free to do so without risk of infringing patents that might be held by third parties? The general answer is no. There is no shield against liability unless they're producing these pursuant to a government contract. And if a government contract is involved, then the government is on the hook for paying a reasonable royalty to the patent owner. But I'm not sure that will come up for anyone, so that's just something to think about. The other issues about COVID-19 is what effects on patent prosecution deadlines. I mean, there are closures all across the world, so let's talk about a few of these. So in the United States Patent and Trademark Office, most transactions can be completed remotely. So there really should be continued operations without interruption because everything can be filed online. The USPTO does not have the power to extend these deadlines, but what they have done is they've said that they will waive any sort of revival petition fees. And those petitions are to revive an accidentally abandoned application. But these waivers only apply to USPTO communications like responses to office action, not statutory filing deadlines like the 1 year from your date of public disclosure. Now, the issue there is they haven't really defined what the standard for the petition is, because they say the deadline needs to be missed as a result of COVID-19. But what do they mean? Just that it became inconvenient to meet the deadline, or it became physically impossible? So seeing what kind of standard they're going to use will bear light as to how effective that will be. And they have, like many places, they've closed their office to the public, so all in-person examiner interviews and PTAB hearings will be either rescheduled or reformatted so they can take place remotely via phone or video chat. The European Patent Office, again, it conducts most of its business online as well, but they have said for any deadlines falling on March 15th or later, we're going to push those back to April 17th. Provided that you can show us evidence that the COVID-19 was the reason for the delay. This also includes any sort of PCT deadlines where if you're going into the national phase, but in that case, you have to present evidence that there were COVID-19 delays in your home country. So for us, we would have to show not that there were problems in Europe, or the European Patent Office, but we had problems here in the U.S. All oral proceedings will continue to proceed, but upon request, they can be done remotely. And the only real action they've taken is they're requesting that people from high-risk areas abstain from visiting. Now, Italy, their Patent and Trademark Office is staying all deadlines falling between March 9th and April 3rd. The UK Intellectual Property Office is operating as normal, but will extend deadlines where legislation allows. Now, China, you may be able, they're kind of operating back to normal now, or at least they're getting there, but you may be able to extend deadlines because most of the deadlines may, for a fee, be restored within 2 months of the pandemic's end. How you define pandemic end, I don't know, but that end may be coming since China seems to be recovering. There are also court closures that you need to think about. So there was a patent infringement suit in California. It was Finjen versus ESET, and they declared a mistrial. They just basically said, we can't continue to have this trial right now, so we're going to declare a mistrial and we're going to reschedule the whole thing. There are hearings across the nation, both state and federal levels, that are being rescheduled. And there was even one case where a U.S. deponent basically refused to be deposed in China not too long ago and won. They said, yeah, you either depose them here or you reschedule the deposition. There are also some other lawsuit things that are being affected. For example, there was a company called Fortress that sued a couple companies for infringing a blood testing patent that they owned. Unfortunately, that 2 days after that lawsuit was filed, the company that was being sued made a public announcement that they were using these patents to come up with COVID-19 testing. As you can imagine, public backlash was pretty bad, and Fortress withdrew the lawsuit. There was also an Italian company who threatened an infringement suit against 2 Italian engineers who for infringing their patent, and the patent was on some valves that were needed for respirators, and because of the supply and demand over there, the issues that they were having, they started 3D printing these and providing them directly to the hospital. And again, the backlash was immediate, and so the threat was of the lawsuit was withdrawn. So that brings us into the recent eligibility changes that have occurred in the patent law. So 35 U.S.C. 101 is the section that deals with eligibility, and it says whoever invents or discloses any new or useful process, machine, manufacture, composition, or matter, or any new or useful improvement thereof may obtain a patent. However, there are 3 judicial exceptions to patentability, which we're not going to allow the patenting of laws of nature, natural phenomenon, or abstract ideas. Now, in 2012, there was a Supreme Court case called Mayo versus Prometheus, where the Supreme Court held that a medicine dosing determination process was not patent eligible. The patent was directed towards the treatment of an autoimmune disease, and because in those cases dosing varies from patient to patient, they came up with a way of measuring known metabolites from the drugs to determine the amount of dosing. Well, the district court found that that was just a law of nature about the known metabolites and found it invalid. The Federal Circuit, when it got appealed there, said, no, this is patentable because it's directed to the entire process, not just the measuring of a known metabolite. But the Supreme Court finally reversed and said, no, this is patent ineligible. But they did give a caveat, and they said, and we must recognize the role of Congress in crafting more finely tailored rules where necessary. We need not determine here whether, from a policy perspective, increased protection for discoveries of diagnostic laws of nature is desirable. And that will come into play later, as you can see with what they've done. But anyway, so the result of Mayo is that they came up with a two-part test. The first part is, does the invention relate to a judicial exception, being a law of nature, natural phenomenon, or abstract idea? And if so, does the patent restrict other use of the exception? And if the answer to that is yes, you're not going to get a patent, or your patent will be invalidated. Then in 2014, there was another Supreme Court case called Alice versus CLS Bank, and this dealt primarily with software. And in this case, it held that the computer-implemented method of conducting escrow for financial transactions was not patent eligible. The district court invalidated this as being an abstract idea simply carried out by a computer. The Federal Circuit originally reversed the district court, but then it held an en banc, just meaning a full 10-judge panel hearing, where the patents were ultimately invalidated, but the 10-judge panel could not agree upon a single standard for what is to be considered an abstract idea. So then the case went on up to the Supreme Court, and the Supreme Court held that the patents were invalid, and they set forth a two-part test, which is, does the invention relate to a judicial exception? If so, is there an inventive concept ensuring that the patent in practice amounts to significantly more than a patent upon the ineligible concept itself? And what you'll see is, we'll talk about this a little later, but essentially, you can't just invoke the idea of automating something and just saying, well, I'm now having a computer do it. If you're going to have computer-enabled things, it must be to enable the computer to operate more quickly or efficiently or solve a technological problem, as was expressed as recently as March 6th of this year. So here's what the test kind of looks like for Mayo Alice. You've got step one that says, is this a process, machine, manufacturer composition? That's regular 101. If not, you are never going to get a patent. Then it looks to but if it is, it goes to step two, part one, which is the claim directed to a law of nature, a natural phenomenon, or abstract idea? If it's not, you get a patent, potentially, if you qualify for novelty and non-obvious. But if it is, you have to look, does the claim recite additional elements that amount to significantly more than the judicial exception? And if it does, then again, you might go on and get a patent. If it does not, then you're going to be rejected. Now, the last thing I want to talk about before we take a break to handle any questions are the recent changes to the USPTO's patent eligibility guidance. These were issued in January of 2019 due to the growing number of cases and inconsistent outcomes. So the Patent Office took it amongst itself to provide some guidelines that its examiners would use for examining patent applications. And the first step is the same, is directed toward statutory materials such as a process, machine, manufacturer, composition. Step 2A, again, does it recite a judicial exception? Law of nature, natural phenomena, nothing has changed there. Now, for abstract ideas, it has given an all-inclusive list saying an abstract idea is a mathematical concept, a method of organizing human activity, or a mental process, period. And that's all. If it is not one of those three things, it is not an abstract idea. Now, if it is an abstract idea, If it's not an abstract idea, you go on and you look at novelty or non-obviousness, you might qualify for a patent. But if it is one of those three judicial exceptions, you go to step 2A, prong 2, which is the claim directed to the recited abstract idea, which looks to whether or not the exception is integrated into a practical application. And they give examples of what this looks like. Does the exception work to improve the function of a computer? Is it used for a particular treatment of a disease or medical condition? Does it apply the exception with or by use of a particular machine? Does it transform an article into a different state or thing? Or is the application in some other meaningful way beyond generally linking the exception to a technological environment such that, the computer does it? And if the answer is yes, you're out of the eligibility question. You go on to section 102 and 103, novelty and non-obviousness. But even still, if you don't pass that test, you then look at, is there an inventive concept that provides significantly more than the judicial exception? So what you can see is the Patent Office is really trying to relax the standards in which they give a patent for these judicial exceptions. But remember, this is the USPTO's test for patentability, it's not the court's test for validity. So if you get a patent, that doesn't necessarily mean it's going to be hold up in the court system. And this is just an outline of the way it looks, the flow tree. But I think now would be a good time to take a quick break and answer any questions that there might be.
Great. Thank you so much, Hunter. Such an informative first session. I want to encourage everyone on the line to start typing in those questions in the webinar controls. We've got a bunch of great questions that have already come in. So Hunter, I'll let you take a quick sip of water and I'll just dive in. So the first question is, we have a company that has developed a face mask that has not yet been patented. If they outsource production of this face mask, is there any way to protect their design with an NDA or other legal tool until a provisional patent can be filed?
So yes, obviously the best thing to do is to file even a provisional application. Those can be done quickly and cheaply, but if that is not an option, or if you've already made the disclosure, then there are things like the non-disclosure agreement that will take it out of the public disclosure. So any sort of secret or experimental uses are not necessarily public ones that will start the clock running. So yes, you can use NDAs and the like to help protect your design until you can get an application on file.
Great. Thank you. I appreciate that. So here's another question that has come in. The question is, how should I handle ideas for my new applications that I developed for my already patented process? And when, during the ideation process, does the 1-year provisional clock start ticking?
So there are two things that I would suggest in that. You can file what are called serial provisionals. So if you've got improvements that you're making but you don't have them finalized, you can file multiple provisional applications. Again, those are the little placeholders. And then when you file a non-provisional, what you do is you can claim priority back to that whole group of provisional applications. Now, remember, you would have 1 year from the date of the first provisional application to file the non-provisional, claiming priority to any or all of them. But when does your 1-year clock really start for having to file something? It starts the moment that you publicly disclose, use, or sell the invention without any sort of secrecy restrictions.
Great, thank you. We've got 3 more questions that have come in. Let's see, regarding the Defense Protection Act, if a company outsources their patented product to another firm to produce, the patent holder is not protected, or is it that the outsourced producer is not protected unless there's a government contract? Please clarify.
So if the patent holder is giving permission for another person to do it, then there's no issue, because then the manufacturer has a license from the patent holder. What the Defense Protection Act says is that the president can order private companies to manufacture certain equipment. So what happens if one of the private companies is told to produce one of these face masks that is subject to patent protection? And what do they do then? That is when you do not have protection against patent infringement. So you need to do one of two things. If you have been ordered under the Defense Protection Act, you either need to enter into a governmental contract to protect yourself, or you need to approach the patent holder and say, hey, look, we've got an emergency crisis. The Defense Protection Act is here. Can we work out some sort of license on a temporary basis, maybe even a royalty-free one, given that it's a national emergency?
Okay, so that piggybacks really well into the next question, and I think I'm gonna make this the last question for now, so we can dive into the second half of your presentation, and we will address the other questions at the end. So the last question for right now is, what is the possibility of march-in rights by the government in light of the current socioeconomic climate?
Wait, can you repeat that question, please?
Sure. So is the government able to march in on any of your patented personal protected, device or whatever it is, in light of the current economic climate and crisis?
Generally speaking, yes. The government does. Remember, I told you that your rights were exclusionary. There's nothing that says that you actually have the right to do things, and the government has certain leeway. Now, historically, the government doesn't do that. It's not, especially this administration, doesn't really want to put any sort of limitations on private business where they can avoid doing so. So most of the time when you're dealing with like a Defense Production Act or some sort of like eminent domain or something like that, where the government is taking property, they have to show some reasonable relation to the state interest that is to be protected and the action being taken. So, for example, could they come in and say, well, we want to take your patent on automotive, some sort of probably not. It would need to probably be something relating to COVID-19. But if there is some rational relationship between the crisis and the patented product, then yeah, there's a good chance. Now, with that being said, the government has to pay you a reasonable royalty, so they don't get to do it for free.
Great. Okay, we've got two more questions that have come in, and I will hold those to the end, and I will put myself back on mute, and I will let you take over now and continue on with your presentation. Thank you.
Okay, thanks. So I wanted to finish up the eligibility changes with just some patent drafting tips. So for medical devices and diagnostics, you really want to focus the diagnostic claim on actions rather than correlations, because the correlation between a national product and or the law and disease states are generally not eligible. For instance, but the treatments and other actions typically are under steps 2A, prong 2 and step 2B. For example, there was a recent case in March of 2020 called Illumina versus Ariosa Diagnostics, where the patent dealt with the method of extracting fetal DNA from a pregnant woman based on the size difference between the fetal DNA of the mother and the DNA of the fetus. And the district court, actually it was a patent appeal. The patent office originally rejected this, and they said this is, actually the district court rejected it and said it was invalid, but then the Federal Circuit came along and said, no, it does actually have a natural phenomenon, but what is being protected is the extraction preparation techniques, which are influenced by the natural phenomenon, but what it's not protecting is the natural phenomenon itself. So you always want to talk about what your preparation is, what the actions are, rather than the correlations. Then obviously, if there are any technologies or systems that are used during the diagnostic methods, those are going to easily pass any sort of 101 test. And then describe your diagnostic method in detail, because claims that are overly broad or generically recite detection of national products or laws are going to be ineligible. So the more detail that you have to rely on for your claims, the better. And then truly avoid any statements that a step is conventional, routine, or well understood, because that, if you make it all the way to step 2B of the practice examination guidelines, where is there something significantly more? If it's conventional routine, you're not going to pass that test. Now, for software, avoid claiming specific algorithms, because that is a direct route into a mathematical concept exception rejection. But you should include statements that the method or process is too complex for humans. There was a recent patent appeal in June of 19 where the patent was granted based on the specification statement that the computer assisted method was conceptually complicated, conceptually intensive, and challenging. And so they said, okay, this is too complicated for humans to do themselves without the aid of a computer. We'll see how that goes in the future. And then emphasize any sort of improvements to computer functionality that you have. So those are the drafting tests or tips that I have. Now let's just take a couple of the statistics. We'll run through these pretty quick. But the light blue is 2010, the dark blue is 2019, and what you'll see is that if you look up here, subject matter, in 2010 you had 2. And now in 2019, you have 57. Whereas if you look at anticipation novelty, you had 28 in 2010 and 11 in 2019. And you have a similar discrepancy in obviousness. So what that tells you is where patents used to be rejected based on novelty or non-obviousness, they're now being rejected primarily on subject matter. But they're also being rejected on indefiniteness, because when you're not defining these things, when it comes to, well, is this or is this not a judicial exception, they start looking at the definiteness of the claims and the description. So you can see the shift of what people are, of how patents are getting rejected. Now, from July 2014 to June 2019, 781 patents were invalidated. This is a 1,056% increase in litigation claims of ineligibility as compared to the 5 prior years. Ineligibility has become the #1 defense, and there's a good reason for that, because it's working. There's a 914% increase in patent invalidation as compared to the prior 5 years, where 58% of all reviewed patents are invalidated, and 62% of all reviewed claims are invalidated. Since Mayo, the Federal Circuit has invalidated every single medical diagnostic claim that it has considered. And then the issuance of software patents is greatly reduced. It has been as much as 50% reduction in the year following Alice. Now, you'll notice that the PTO is relaxing these standards somewhat in light of the 2019 the examination guide. So now, is clarification coming? Well, I don't know. The answer doesn't look good right now, but in 2019 there was a case of Athena versus Mayo, where the Federal Circuit basically requested the Supreme Court clarify its eligibility test. The Federal Circuit invalidated the Athena patent, which was directed towards a method for diagnosing an autoimmune disease. They said it was ineligible as a natural law. But you could tell none of the judges wanted to do this, and they couldn't agree on how to do it. For instance, Judge Dyke said it's the Supreme Court, not this court, that should consider the breadth of Mayo. Judge Moore said the math is simple. You need not be an economist to get it. Without patent protection to recoup the enormous R&D costs, investment in diagnostic medicine will decline. To put it simply, this is bad. It is bad for the health of American people and the health of the American economy. And it's avoidable depending on our interpretation of the Supreme Court's holding in Mayo. In fact, the Department of Justice submitted a brief asking the court, saying the Supreme Court really ought to take this case up. And a couple more quotes from this is Judge Newman said, this case presents an opportunity for judicial review and judicial remedy. Although diagnostic methods are not the only area in which Section 101 jurisprudence warrants attention, Federal Circuit precedent is ripe for reconsideration specific to diagnostic methods to correct our application of the Mayo decision and restore the necessary economic incentive. And there's several more, but I'll skip all those. Despite these requests, there have been 8 eligibility cases for which Supreme Court review has been sought, and the Supreme Court has refused to hear all 8 of them. So it doesn't sound like the Supreme Court wants to deal with these. And remember back to what they said in the Mayo decision, which it's the role of Congress. So basically the Supreme Court is kicking this issue over to Congress and saying, we're done. We've done what we can do. Congress, it's your turn. So let's talk about what types of legislation is out there. The biggest and most talked about one is the one between Senator Tillis and Senator Coons, which was originally proposed in 2019. And this would actually make the test much more like the examination guidelines from the PTO. And that says it basically would replace the judicial exceptions with this list of fundamental scientific principles, products that exist solely and exclusively in nature, pure mathematical formulas, economic or commercial principles, and mental activities. And it would create a practical application test, much like the one in the PEGs, to ensure that ineligible subject matter is construed narrowly. However, there have been several hearings held since it was introduced in May of 19. There was a formal introduction that was promised after July 4th. Nothing happened. In fact, in a recent interview, Senator Tillis said, I don't see a path forward for producing a bill, much less steering it into passage in this Congress. But there are other people like Representative Johnson, who's the chairman of Courts and IP Subcommittee, who said, hopefully before the end of this session of Congress, we'll have something. So keep your eyes open. We'll see. But in light of COVID and the fact that it's an election year, I doubt it. There's also the Stronger Act, which stands for Support Technology and Research for Our Nation's Growth and Economic Resilience Patent Act, which was introduced in March of 2019. This primarily deals with patent office proceedings for challenging validity of patents. It would make it more difficult to institute these proceedings by limiting the numbers that may be brought against a patent. And it also eases the standard for obtaining preliminary injunction in district courts by the patent owner. This was initially introduced in 2015, but again reintroduced in 17, 18, and again in March of 19, and still nothing has happened yet. So then we have the Inventor Rights Act, and this was introduced in December of 19, and it provides substantial new rights to inventor-owned patents, which must be owned by the inventor or the entity controlled by the inventor. It would expressly exclude large corporations, drug companies, or typical non-practicing entities from the rights provided by this act. And what it says is the Patent Office may not review a patent for validity without the inventor's consent, that those reviews must be done in a court setting. And it would also allow recovery of profits from infringement. Remember, we talked about the remedies, and the most typical one is the reasonable royalty. It's very difficult to get lost profits. This would make it much easier. It would also provide treble damages for willful infringement, plus any portion of the attorney's fees the patent owner incurs that exceed 10% of the recovered profits would also be recoverable. So it's making it easier to enforce your patents. Another similar one is the Inventor Protection Act. This was introduced in 2018, and it again applies to patents owned by the original inventor, not the entity controlled by the inventor, but the inventor himself. And again, the Patent Office may not review the patent for validity without consent. It would allow the inventors to sue in their home state regardless of where the infringement occurred. It would shorten and simplify infringement lawsuits. It would award the patent owner the greater of the profits, or 25% of the total infringing sales. It would entitle them to treble damages and attorney's fees. And it would create a presumption that the inventor is entitled to injunctive relief, because sometimes an injunction can be very difficult to get under the standard of irreparable harm. Moving on, what other type of legislation out there? There's the Term Act, which deals with drug pricing. So anyone in the medical industry or the medical diagnostics and pharmaceuticals would be interested in this. This was introduced in June of 19. And it basically says once the first patent on a particular drug expires, all the other ancillary patents on that drug are presumed to expire also. This is to prevent the evergreening by patenting small or what they call trivial changes to expand the patent term of these drugs. It does provide an exception where the drug company can rebut the presumption by showing that one of the patents has a patentably distinct change. We don't know exactly what that test is going to look like under the Term Act, whether it's going to use the tests that are currently in place or come up with a new test. There's also the Prescription Drug Affordability and Access Act, which was November of 19. It would create an agency to review and determine the appropriate drug prices. And once those prices are set, if the drug is sold above that set price, the agency can invalidate all the patents on that drug. So it's basically the government setting the price, period, or you lose all your patent protection. There's at least 5 other bills, but they don't relate to patent law reform. So moving on to design patents, this is actually a very good act, and it's called the Counterfeit Goods Seizure Act of 2019. Was introduced in December of 19, and it basically expands the authority of the Customs and Border Patrol to seize goods that infringe intellectual property, and they've expanded it to now include design patents. Prior to this act, the patent owner of the design patent had to first obtain an exclusion order from the International Trade Commission, which was timely and expensive. Now they can simply register their design patent with the CBP. This has gotten broad support. It was a bipartisan bill, as well as the AIPLA and several other industry groups have supported it as well. So there's 2 more that we need to talk about in terms of patent legislation. The U.S.-Mexico-Canada trade deal. It was recently approved by the Senate and it awaits enactment. Canada and Mexico have both ratified this. The IP provisions largely align with the Trans-Pacific Partnership negotiations. It adopts strong patentability standards in all fields, including new uses of a known product. It adopts the 1-year grace period between disclosure and application that we apply here in the U.S. It provides for patent term extensions for delays that are greater than the later 5 years from filing or 3 years from request for examination, because the patent office and other patent agencies oftentimes delay things quite a bit. Then it would also create a committee on IP rights to strengthen their border protection and to establish fairness in patent litigation that was going across the borders. However, there is a 5-year implementation period, so there's nothing that's going to happen immediately. One thing that was left out is the Act originally sought a 10-year term of protection for biological drug data. That was rejected and pulled, so now there's 8 years in Canada for protection and 5 years in Mexico and 12 in the U.S. And this proposal was basically to make it conform to the Biologics Price Competition and Innovation Act, which basically presented the introduction of biosimilars for 12 years from the date of licensure here in the U.S., but that was pulled, so we're just status quo on that. And then the U.S.-China trade deal. So phase 1 was signed in January 15th. The Chinese have until April 14th to put in their plan of action. But essentially, they look at patent term extensions for unreasonable delays, basically 4 years from filing or 3 years from the request for examination, whichever is later. And then for pharmaceuticals, when you're seeking commercial approval, you can get no more than a 5-year extension, but you can also get no less than a 14-year patent term. The China Patent Office will now also consider supplemental data during examination to overcome any sort of obviousness rejections, so test results and things like that. There's also an early resolution for patent disputes where the patent owners would be notified of any generics that are coming out, and they would be given an opportunity to bring any sort of infringement suits before the generic ever makes it onto market. Some other things. China would be combating online infringement with takedown notices, so it would require an expeditious response. Similarly, where if you see someone infringing your patent or your trademark or your copyright online, you could write to the ISP and say, someone's infringing it, you need to take it down. So there's basically some things that China has to do to comply with that a little better. And then, in fact, one of the things that can be done is you can revoke the operating license for repeated failures of an ISP to curb the sale of counterfeit goods on their websites. And then lastly, they're seeking increased protection from trade secrets. The main concern here was that they thought that Chinese governmental agents were disclosing trade secrets to Chinese corporations to give them a leg up. So there are some things that are being done to to handle that. And then there's artificial intelligence and created inventions. The patent applications seeking protection for AI-created inventions have been filed in the European Patent Office, the UK Intellectual Property Office, and the USPTO. As a result, the USPTO has laid out a number of questions about what changes, if any, are necessary to the patent laws to deal with inventions that are created by AI. So that's not inventions relating to AI, but inventions that are actually created by the AI entity itself. They also asked some additional questions relating to copyright protection, and that response period is ended in January 10th of this year. Now, as far as what happened to those applications, the EPO rejected both of the applications because they basically said, no, an inventor has to be a natural person. And so they may appeal that decision. The inventor may appeal that to the boards of appeal, which I believe is pending. The UK similarly rejected its applications in the parallel national phase case, basically saying it's got to be a real person, not a machine. So the implications of this is, if it's unpatentable, what protection, if any, is available for AI inventions? And can AI execute the oath if it is allowed? And then who owns the patent? Is the machine or the creator of the machine? As far as what's going on in the U.S., we don't know how they're treating these applications yet. That still hasn't been disclosed. However, I can tell you that the USPTO is rejecting 90% of AI-related applications as abstract ideas. So again, this is AI-related, not AI-created. So I see that we're pretty close on time. So Julia, you tell me if you want me to open it up to questions or if you want me to go through a couple more slides.
Let's see. Let's run through these questions real quick, and then I am more than happy to leave the line open, and we can continue the presentation. I mean, do you think you could run through the slides in a minute, and then maybe we could tackle these questions in 2 minutes, or do you want to do the questions first and then?
Let's do the questions, and then for those who need to go, they can go. Anyone who wants to stay, I'll be happy to run through the rest of the slides.
Okay, great, thank you. Okay, so 3 quick questions here. Number 1, are there programs for very small businesses which can subsidize the cost of getting a patent?
So are there programs? Not that I know of, but there are. You're in the right place. I mean, you're dealing with SCRA, so there are entities like SC Launch and SCRA or UCAN. Oh, well, I guess it's not UCAN anymore. It's Venture South. But there are definitely there are entities who can help provide that type of capital. But I don't know of any sort of like governmental program sponsored by the USPTO that would help with that. So you just have to find investors. But I would say get in touch, start with SCRA, because that is a very good resource in how to get yourself some funding.
Great, thank you. The next question, can you obtain a design patent if that design also protects function of a device?
So you can get both a utility patent and a design patent. However, you have to be very careful because the presumption is that if you have a utility patent on the aspects that are trying to be protected by the design patent, that is evidence that the ornamental features are functional themselves. But the real question is the design dictated by the function? If the answer to that is no, then you can get both a design patent on the ornamental features and a utility patent on the functional features. But where the more overlap you have between what's functional and what's ornamental, the less likely you are to be able to get a design patent.
Great, thank you so much. So I'm just going to pause at this last question, and then I'll let you dive into your questions. And then if other questions do come up, then maybe you could answer them offline, and then we could send out the answers to those questions via email. So here's the last question. If you use public mathematical algorithms, but adapt to specific use cases on manufacturing equipment as templates, can these templates be patented?
So can the templates themselves be? Yes. This goes back to kind of the prenatal extraction method, where just because the actual product is the result of a purely mathematical concept doesn't mean that the product itself is not patentable. So, but the mathematical concept itself would not be patentable. So yes, that's the difference. Is are you looking at? So this would be the practical integration step of the PEGs. Like, is the exception being used into a practical application? And the answer to that should be yes in that case.
Great, thank you. So there were just two more questions that came in, but I will save those until the end. So I'll let you finish your slide deck. Go right ahead.
Okay, thanks. So I wanted to talk a little bit about the bars of patentability. There's been a little bit of a change in a recent case, which is now pending before the Supreme Court, which is Medtronic versus Berry. And the issue is, must the invention work for its intended purpose to trigger the on-sale bar to patentability? So the on-sale bar basically says that you cannot receive a patent for inventions that were in public use or on sale more than a year before the filing date, because that's a public disclosure. And traditionally, that clock starts when the invention is used publicly and is quote-unquote ready for patenting. But there is an experimental use exception, which traditionally non-commercial uses to determine the usefulness of an invention would prevent the clock from running. There's a 13-factor test. I won't go into it right now. But the question is, must the invention work for its intended purpose? If so, how do you determine what the intended purpose is and whether it was achieved? So the Federal Circuit, in the most recent holding in Medtronic, basically said the one-year clock starts when the invention works for its intended purpose, and that the intended purpose may be determined from its extrinsic evidence. So in this case, I'll kind of briefly say it. What happens is that right about here, you've got your prototype. So you've got a reduction to practice. That's typically when your clock starts. Well, now you've got a use of this prototype to perform surgery. So that's a public use. So normally people would think that one of these three deadlines would be the one-year clock. However, in August and January, the doctor followed up with his patients to see how they were recovering from the surgery. But as you will see, this date when he files his patent falls within the 1 year from January, but doesn't fall within the 1 year from there. So the question was, well, does this qualify for an experimental use? And the Federal Circuit basically said, yes, it does. It was not ready for patenting until the surgery occurred and the follow-ups were completed. It was really weird. They found this to be an experimental use, despite the fact that there were third parties present who had not signed NDAs. The doctor received his regular compensation for conducting these surgeries, and none of the patients were ever informed of the experimental nature of the procedure or the tools being used. The Federal Circuit relied exclusively on the doctor's after-the-fact testimony that he said he needed to do these surgeries to see if the devices worked. Is pending before the Supreme Court. Is it likely to hear? Probably not. It's very fact-specific, and the Supreme Court is basically denying all patent cases. But the takeaway here is avoid unnecessary risk. Go ahead and file before you start using this. And if you're not going to do that, you better explain why the experimentation was necessary. You better use non-disclosure agreements for anyone who's going to be there. You better inform your customers of the experimental nature. And if I were you, I wouldn't accept compensation, because it looks like you're just conducting business as usual. The last thing that I will talk about is some patent agreements in merger clauses in specific. And there was a recent case of Molon Motor versus NIDAC, which goes back all the way to 2004, where Molon sued NIDAC over 3 different patents. Well, NIDAC basically said, we believe that 2 of your patents are invalid, and so they asserted those claims in the lawsuit. So Molon basically said, well, we'll tell you what, we'll give you a covenant not to sue on these 2 patents if you will withdraw your invalidity claims. So this left only 1 patent in suit. At the end of that dispute, they had 2 agreements. One was the covenant not to sue on the 2 patents, and then they had an exclusive license to use all 3 patents. And so in 2016, Molon sued NIDAC saying that you're using these inventions outside of the licensed territory, therefore you're committing patent infringement. Well, NIDAC, being very smart, they said, well, wait a second. You signed back in 2006 covenant not to sue us on these 2 other patents, so you're precluded, at least from those 2 patents, from suing us. And Molon said, well, now wait a second. In the license agreement that we entered into in 2007, just a year later, we had a merger clause that says all prior agreements, quote, concerning the subject matter hereof are merged herein and shall be of no further force and effect. And of course we meant that covenant not to sue on those 2 previous patents because we wanted the license to take over. Well, the Federal Circuit disagreed with them, and they won. They reprimanded Molon and said, guys, if you wanted it to cover that agreement, why not say that in your license agreement? Instead of the 1-sentence merger, say, you could have included, including but not limited to the 2006 covenant not to sue. And so anyway, they looked at the differences between these 2 agreements, and they said, no, the covenant not to sue is still a valid agreement and has not been relinquished or extinguished by this new settlement agreement. The takeaway is, if you are trying to enter into a new agreement which is going to extinguish prior agreements, reference them by name. Don't just have a 1-sentence, all prior agreements are hereby extinguished. So that is kind of the end of the presentation. There were some other things on patent litigation that have gone on in the patent world, but hopefully none of you are involved in patent litigation. But if you want to find out more about what's going on in front of the Patent Trial and Appeal Board, or kind of some trends that are going on in district courts, I'd be happy to talk to you offline. But for today, those are the hot topics that are dealing with patent protection in general. And I hope you found this informative. Thank you again for attending, and I'm happy to answer any final questions.
Thank you so much, Hunter. I just want to say that we have received not questions, but a lot of comments into the question webinar controls section, just saying thank you so much for such a great and clear webinar, very informative. And so I just want to articulate those to you, and thank you to everybody on the line for joining us. We do have one more quick question here, so I will pose that question, and then if you have other questions, Hunter has included his email address and his phone number here if you'd like to contact him. But here's the question, the last question on the table. If a Chinese prototype company is used to manufacture a new product and subsequently the patent holder discovers their product being produced by a Chinese manufacturer, what resource does the U.S. company have to stop this production?
So if I understand the question correctly, is what happens when the infringement is occurring in China? Well, the answer to that depends on what patent protection you have in place, because if you don't have a patent in place, then the answer is you really don't have any recourse against this company unless you have some sort of contractual obligations that you can enforce. Now, what happens if all you have is a U.S. patent? If you have a U.S. patent, the one thing that you can do is you can now register your patents with the Customs and Border Patrol, so that any allegedly infringing items that are being imported can be seized. But even if it makes it past the border protection, you can file a lawsuit for patent infringement based on the importation and or the inducement of infringement, because if this Chinese company is importing these objects, the direct infringement by the Chinese company is the importation, but the inducement is they are inducing U.S. companies to then sell this infringing product. And remember, one of the things you can prevent is third parties from selling or offering for sale. So you can sue both the Chinese company and the U.S. distributor for patent infringement based on that. Now, if you have a Chinese patent, you could go over to China and you could prevent the manufacturer of that. However, I will say, being an American, you have to have a very strong relationship with a boots on the ground type of Chinese entity. Otherwise, these companies close down and open up, a week later just down the street. So you really have to have an enforcement partner in China.
Great information. Thank you so much. Those are the last of our questions. I want to thank everybody on the line for joining us. This has been a really full attendee list, really great people on the line. I appreciate the smart questions. And Hunter, to you, I appreciate you a lot for joining us. Our next webinar is April 9th. The topic is growth versus scaling. Please go to our website to register and sign up for this next webinar. Thank you again, Hunter. I just want to say goodbye, and thank you to everybody on the line. Goodbye, and have a great and safe day.
Thank you. Bye-bye.
Bye.